Hi everyone, I'm Sasha Denis, and today I'm going to be asking some of the most common questions there is for Duty Counsel. Je m'appelle Sasha Denis et je vais demander les questions les plus communes demandées par les gens à propos de la service l'avocat de service. On our panel today are Deanna Harris, youth and criminal lawyer from Saskatchewan. Megan Johnson, immigration and refugee lawyer from Ontario. Paul Storty, family welfare lawyer from Nova Scotia. Nicola Langille, youth and criminal lawyer from the Northwest Territories. Thank you for being here. Okay, so the first question is for Deanna. So what is Duty Counsel?
Hi, Sasha Denis. Since it's National Duty Counsel Day, I'm going to brag a bit and say that Duty Counsel are kind of this secret superheroes of the legal system. We're lawyers paid for by the government whose job it is to help people who need legal advice and representation who can't access or otherwise hire a private lawyer. We have a number of people on the panel today who are duty counsel in their own territories and provinces. And later on in the presentation, they're going to be providing you with overviews of more specific overviews of what they do. But generally, we have Nicola and myself, and we represent people with respect to criminal duty counsel. So that means we help people who are charged with criminal offenses in the justice system. We also have Paul from Nova Scotia, and he helps people in the area of family law, which means that he can help with things like divorce, child support, and child and family services matters. We also have Megan from Ontario, and she helps people in the area of immigration law. So that means that she helps people who need advice and representation at things like immigration tribunals or refugee tribunals. So legal systems are really complicated and they're overwhelming for people who've never had contact with them before. Duty counsel are employed to give advice, to guide, and to represent people who become involved in these systems. We do a lot of different things for a lot of different people, but the main thing to remember is that we are lawyers who will help you free of charge with your legal issue. We don't have a bat signal, but legal aid plans do have websites, so you can definitely find us on Google.
Okay, thank you. Okay, next question is for Megan. Why should someone have duty counsel if they don't have a lawyer?
So if someone is eligible for the services of duty counsel, I would always advise that they use these services. Just like Deanna said, duty counsel are the superheroes, secret superheroes of the justice system. And as Deanna also noted, legal matters can be very complicated. And a lot of the time, they're more complicated than people might realize. They also have really serious consequences. Again, sometimes those consequences can be more serious than people realize. So it's always better to get advice or get representation from a lawyer so that you can make the best decisions possible in the case of getting advice, or in the case where someone's eligible for representation, that they have the assistance of someone who has the knowledge and experience to try to get the best possible outcome for you.
I have a question for Nicola. When you go to court, can you hire duty counsel to be your lawyer?
It's a great question, Sasha Denis, and the short answer is no, you cannot.
Why not?
Well, so as Deanna mentioned, duty counsel is paid for by the government, and it's meant to be for everybody who needs some advice, and to make sure that nobody goes through the court process feeling alone. So duty counsel does this work no matter how much money you make, and no matter whether you can pay for a lawyer or not. In short, we're hired by the state and not by individual clients. And so that means that you can't hire us to be your private lawyer.
Thank you. What kind of things can duty counsel help with? Paul, what can family duty counsel help with?
Thanks, Sasha Denis. We can help people understand the rights and responsibilities of parents, guardians, and children We can explain the law and how the law applies to a particular situation of a person. We can help them determine what forms are required to be filed with the court. We can help them interpret court orders and talk about the implications of following or not following a court order. We talk about all areas of family law and give advice about it, such as child and spousal support, parenting issues, property, pensions, separation, even child welfare. We may offer, and a lot of times we offer what we would call coaching to help people decide to go forward settlement proposals, helping them prepare for settlement conferences, motions with the court, trials, preparing documents. In child protection in Nova Scotia, there's a pilot where we can actually appear with parents and youth on a early stages of the court appearances. And we also assist in filling out forms for court applications and motions. And that's just a few of a list of what we can do.
In Saskatchewan, we can help adults who've been charged with criminal offenses who are in custody. We can help those individuals with bail hearings, which means we try to get them out of jail or negotiate their release from jail if they've been arrested and are remaining in custody. We can also help those individuals with guilty pleas, sentencings, which means the kind of if they want to accept responsibility for the crime that they're charged with, we can help them with that phase. So accepting responsibility and arguing for the most fair possible sentence for them. And for in custody as well, we may open a full service file and do the trials for them. For out of custody matters, we can do adjournments. We can also do the negotiation and guilty plea and sentencing phase. If they qualify financially for Saskatchewan legal aid, then we can also open a full service file and take the matter to trial. With respect to youths who are charged with criminal offenses, we can help with the same things. We can try and argue for them to get out of custody. If they're in custody, we can run trials and we can do guilty pleas and sentencings for them.
Is it the same in the Northwest Territories, Nicola?
So there are some differences in what Duty Counsel can help with across the country. The Northwest Territories, our system looks a lot like what Deanna just described. So we do everything that Deanna mentioned. We help at all stages of the criminal process. So this means that we show up right away when you're arrested, whether you're an adult or a youth, and no questions asked. We're there to help. We do help people all the way through the criminal process. So we do take a number of matters to trial as well, if people qualify financially for that. And so because of that, we sort of see our system as looking a little bit more like a public defender system, as you might hear that term being used in the United States. But by and large, it's how Deanna described it up here. And in other jurisdictions, there are some more limitations, some more restrictions. So there are some variations across the country.
Thank you. And in Ontario, what immigration refugee situations can Duty Counsel help with, Megan?
So we actually don't really have Duty Counsel services in Ontario in the immigration and refugee world. So it's not quite correct to use the term Duty Counsel here, but what we do have in Ontario is that Legal Aid Ontario recently started a one-year pilot project called the Immigration Detention Representation Project, where we're providing representation to all unrepresented individuals in the province who are in immigration detention. So we're representing all these individuals at their detention review hearings if they don't otherwise have a lawyer.
Paul, if someone is in an abusive relationship, how do they get help?
Sasha Denis, that's a very difficult question to answer in such a short time. It's a very complex issue. Persons that we might deal with or meet up with might be at various stages. Some may still be with the person or the situation subject to violence. Some of them may have left. So everybody's situation is unique and different. And I think what we have to do is we have to recognize their situation and basically give information and assist in what way we can. We need to inform them that there's children involved that may involve child protection. We'd certainly inform them of services that are available, like outreach services for transition shelters, talk about and give information about temporary protective shelters, counseling, therapy. We talked earlier, I think Deanna had said about websites. There's some really good websites. In Nova Scotia, it's nsdomesticviolence.ca, has a lot of good resources and contacts. And federally, the Department of Justice, under the Family Law tab, has some really good resources dealing with domestic violence and family violence specifically.
In a criminal case, what does it mean if someone pleads guilty?
So, when you're charged with a crime, it's important to know that it has not been proven that you've done anything wrong. And actually, it's the opposite. We presume that you haven't done anything wrong. That's what we call the presumption of innocence. You might have heard that term before. It's the prosecutor or the Crown's job to prove that you did something wrong. And until they do that, nothing's been proven. And as I call the prosecutor the Crown because in theory, they're representing the Queen. So the Crown acts as the Queen's representative in court and is another lawyer, just like we're lawyers. So there's two ways that it can be proven that you did something wrong. The first is you can plead guilty. And this means that you tell the judge that you accept responsibility for what they think you did or it said that you did. It means you're willing to admit that you did what the Crown is alleging, in short. The second way that you can be found guilty is you can have a trial. So a trial means that witnesses come to court. They tell the judge what happened based on what they saw or what they heard. And the judge has to believe, based on that information, that you actually committed a crime. So those are the two ways that you can be found guilty. You don't have any obligation to plead guilty, even if you did something wrong. It's always the Crown's job to prove that you did something wrong. And you can ask the Crown to prove that you did something wrong by having a trial. If somebody does want to plead guilty, we as duty counsel have to be pretty confident. We have to go through a series of steps to make sure that you understand what it is you're admitting to and the consequences of admitting your guilt. For example, the punishment that you could receive and what that might mean for you. So there's a lot that has to happen for you to plead guilty, and it's not so simple, but that's a guilty plea in short.
Why would someone be held in immigration detention?
So Canada's laws allow for someone to be detained in immigration detention if the immigration authorities believe that they would be unlikely to show up for their immigration proceedings, if the immigration authorities are concerned that someone might be a danger to the public, if the immigration authorities say that the person's detention is necessary while the immigration authorities investigate them, or if the immigration authorities say that the person's identity has not been established. And immigration detention can apply to any individual who's not a Canadian citizen.
How long can someone be held in detention?
So in some rare cases, people can be held in immigration detention for a really long time. The law doesn't actually set out any limits as to how long someone can be held in detention. Now, it's pretty rare, but people can be held in immigration detention for several years if their case takes a long time to be resolved. So for example, if it's hard to get a travel document that would allow the person to be deported from Canada. Human rights organizations that work with people in immigration detention have called for there to be a limit on the amount of time that someone can be held in immigration detention, but we haven't seen that limit come into the law yet.
Can kids be held in detention, like lower, like their age is less than 12?
Yes, that's a great question. And yes, it can be the case that kids can be held in immigration detention. It doesn't happen very often, but it can still happen. The rules that govern the immigration tribunal do say that minors, so that refers to anyone under 18, minors should only be detained in the most exceptional circumstances and for the shortest time possible.
So how does someone get out of immigration detention?
Yes, great question. So someone who's being held in immigration detention will have what's called a detention review hearing. That's kind of like a bail hearing. So that's the hearing to decide if they'll get released. Those hearings take place before the Immigration and Refugee Board, which is an independent tribunal. Tribunal is kind of like a slightly less formal court. So the hearings take place 48 hours after the person is detained. There's another one 7 days later, 30 days later, and then every 30 days after that. At every detention review, the person has the chance to argue that either there's no reason for them to be detained or that their detention isn't justified because, let's say, for example, they have a release plan that would be enough to reduce any risk the immigration authorities are concerned about.
Now, a few commonly asked questions for the Criminal Duty Counsel. If I have a criminal record, do I have to tell a future employer or school?
It depends on whether or not it's a youth or an adult record. As an adult, you don't always have to disclose a criminal record. If you've been pardoned or if you've been granted a record suspension, you don't normally have to. And that means that enough time has gone by since your last criminal conviction that the government might agree to kind of separate your criminal record from the other ones and remove it from the system. So it's not disclosed to on a criminal record check. As an adult, if you've been sentenced to something called a discharge, that's a finding of guilt which results in a temporary criminal record, but it's not the same thing as a permanent criminal record. So you may not have to disclose that. Youth records, so for you specifically, Sasha Denis, they're a different thing than a criminal record. They're findings of guilt under the Youth Criminal Justice Act. So no, youths do not have to disclose their youth records to employers and future educational institutions. There is a myth out there that for youths that when you turn 18, your youth record magically disappears. I think that comes from like American television or something, but that's not true in Canada. In Canada, they can retain your youth criminal record for a period of time. So it could be either 3 or 5 years, depending on what you were found guilty of. And you have to be good for that period of time. And if you're not good and you get in trouble with the criminal justice system again, your youth record could actually become part of your adult record. So for example, if you do something and you were found guilty as a 17-year-old, if the period of time that you have to be good is 3 years, that means that you have to be good until you're 20 and not be found guilty or be convicted of anything else under the criminal code for that period of time for your youth record to disappear. So it's really important that people understand that there's nothing magical about turning 18. Your youth record doesn't just disappear in a puff of smoke.
Now I have a question for Nicola. What's a bail hearing?
So when you're charged with a crime, in other words, when the police think that you did something wrong and they arrest you, one of two things can happen. They can either tell you that you're in trouble if they arrest you, and then they let you go and tell you to come to court at a later date to deal with the situation. That's the first thing they can do. Or the police can tell you that they think you did something wrong and keep you in custody. In other words, they can keep you in jail. In that case, you have the right to what's called a bail hearing. So in short, you have the right to argue that you should be let out of jail while your charges are being dealt with. And it's important to remember when you're charged, it hasn't yet been proven that you did anything wrong. And charges can take a long time to go through the courts. Sometimes you get the impression from television that you're charged one day, your trial is day 2, and then you've served your sentence by day 3. That's not how it works in real life, unfortunately. I wish things would go maybe a little bit faster than they do. But that means that it's important that as many people can be out of jail while they're waiting to deal with their charges as possible, because it can take a long time. So at a bail hearing, basically the Crown and the defense lawyer or duty counsel, so again, the 2 lawyers, argue about whether you should be let out of jail, and if so, whether you should have to follow any rules that are designed to make sure you don't get into trouble.
Thank you, everyone, for talking with me today and helping me learn more about what you guys do.
And now it's my distinct pleasure to introduce our next speaker, the president of the Canadian Bar Association, Stephen Rothstein. Stephen is the Director, Global and Domestic Affairs at the Ontario Securities Commission, where he's also part of the executive leadership team. Prior to that, Stephen was Vice President, Policy and Regulatory Affairs and General Counsel at FP Canada, where he practiced corporate, commercial, employment, IP, corporate governance, privacy, and nonprofit law. Stephen serves on the governance committees of the Credit Counseling Society and 4 Villages Community Health Centre. He obtained his Bachelor of Arts, his BA degree in Political Science and History from the University of Western Ontario, and he obtained his Bachelor of Law degree from York University, Osgoode Hall Law School. He's been a member of the Canadian Bar Association since 2015.